Well, we have another Loco lawyer. This time her name is Dina Doll, and she's going to weigh in on the Kyle Rittenhouse shooting. She is hopping mad. That kid defended himself. Oh my God, we got to do something to stop this kind of crap. And so she's going to write an article for the Bloomberg Law. And of course, Bloomberg is more than happy to print it, describing how California should change its laws to prevent future Kyle Rittenhouses. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dread Show.
Okay, now, this is a local lawyer episode, but it's not real humorous. I mean, keep in mind, this is going to really piss you off. But let's go ahead and read it. And the only reason why it's a local lawyer episode is because she's local. All right, the Kyle Rittenhouse case revealed a gap in gun laws. Dina Doll, and she is a lawyer. California recently took a bold step in the gun rights conversation. Yeah, California. When Governor Gavin Newsom proposed an assault weapons law modeled after the new Texas anti-abortion law. The Texas measure allows private citizens to sue doctors who terminate pregnancies. Newsom's proposal would allow a similar private enforcement mechanism to limit assault weapons. Okay, I don't want to get into abortion here, but abortion, gun laws, they're not the same thing. Just because Texas passed a certain law about abortion doesn't mean California should pass a similar one about gun rights. It doesn't quite work like that. It is often said where California goes, the country follows, due to its sheer size and stupidity. It says economic force of the state. Progressive laws, including gun control laws, passed in California, often become a model that is then adopted by other states to follow. Now you're thinking, well, where's the local part? Yeah, this is terrible news. I mean, nobody wants this, right? But where's the local part? It's coming. Deficiency revealed. Oh, you know it's coming. Considering this influence, California should make another bold move in the gun control conversation by filling a gaping hole in our gun laws, revealed in the Kyle Rittenhouse trial. Get ready? Are you ready? Lawmakers should make it a felony to carry a weapon in public during a curfew. Should a death result in such a scenario, prosecutors could then use the felony murder rule to hold the killer accountable.
Okay, that was weird.
Now, that sounds pretty loco, but you might be thinking, well, come on there, Johnny Walker Dread. This is obviously not going to apply to a person who uses the gun in self-defense. Oh, you would be so dead wrong. Wait. The Rittenhouse trial illustrates the problem with our current gun laws. Yeah, Kyle used his gun to defend himself. That's a problem? She doesn't understand that a jury of all 12 acquitted him. They exonerated him. He's not guilty. And yet, this somehow illustrates a problem with our current gun laws because he wasn't convicted. Rittenhouse, then 17, traveled to Kenosha, Wisconsin during a curfew in 2020. He used a rifle to protect used car lots. Notice what it doesn't say. It doesn't say that he used the rifle to protect himself.
That was local, but not in an entertaining way. Okay.
And now get this. When he left private property, he killed 2 people and injured a third. That's right. Kyle just walked off the property and killed a couple of people. Let's not discuss anything having to do with the ambush, the attacks, anything like that. No. We leave that stuff out. We don't want the reader to get the wrong impression. And you see, this is what pisses her off. Kyle was exonerated. So this is a way to prevent people in the future who defend themselves with their guns from being acquitted. And I know what you're thinking. Well, no, self-defense is going to be covered, right? Hang on. Gun rights advocates saw Rittenhouse's acquittal as a vindication of the Second Amendment and self-defense. You see how she does this? She wants to make the Rittenhouse trial all about the Second Amendment, gun rights. It really wasn't. It was about self-defense. If he had used a knife to protect himself, he would have faced the same charges except for the minor possession deal. And even then, that might have been another case because whether you had had legal possession of the knife or not is another matter. But you see, the Kyle Rittenhouse trial had certain Second Amendment arguments surrounding it, but it was a case of self-defense, and she's trying to sweep that under the rug. Gun control supporters saw it as a miscarriage of justice given Rittenhouse's decision to inject himself into the chaos. No, the chaos came to him. Both sides framed the issue around the gun, but the gun wasn't relevant to the verdict. The judge dismissed a single weapons possession charge before the jury deliberated. Instead, the jury considered a basic non-political issue. Did Rittenhouse act in self-defense? She says it's a non-political issue, but she's going to make it one. Under Wisconsin law, the jury had to consider only whether Rittenhouse reasonably believed he needed to protect himself using lethal force. And of course, she says, under Wisconsin law, and keep in mind, this is her loophole. The jury only had to determine whether he used self-defense legally or not. And that's the problem. She wants him convicted anyway. It doesn't matter whether he defended himself. That's what I've been telling everybody. Gotta listen. She's saying it. She's admitting it. Addressing the gap. The acquittal revealed a gap in the law that California should address. She's said that about 4 times now. Rittenhouse exacerbated an already volatile situation by bringing his AR-15 into a curfew zone. There is no evidence of that. You show me any evidence that Kyle Rittenhouse caused any kind of volatile situation to escalate by his possession of the rifle. You might think, well, what about Jojo Rosenbaum attacking him? There is no evidence that Jojo attacked Kyle because Kyle had a rifle. There's none. And again, the problem here isn't the people that are rioting. It's Rittenhouse. He's to blame. A curfew is imposed by a state or local government when officials believe that restricting public access to a particular area is necessary to protect life or property. Curfews are rarely enacted. They are official acknowledgments that a locale is facing an emergency. Notice what she is not saying. She's not using the word riot. She's going to stay away from that word as far as she can. It is a misdemeanor to violate a curfew in California. With some exceptions, it is also a misdemeanor in California to carry a weapon, whether open or concealed, in public. All right, now here's her argument. California should make it a felony to carry a weapon in public where a curfew prompted by civil unrest is in effect. Such a measure makes sense from a public policy perspective. The authorities already would have limited the public's freedom of movement and assembly in a dangerous area. So in other words, what she's saying is that the authorities have already stripped away certain rights. Therefore, it makes total sense that we can strip away a person's self-defense rights and Second Amendment rights. She's saying it. We've already taken away their right to move, their right to freedom to travel around. This is just the next step. Bringing a weapon into such an already dangerous area increases volatility, as the Rittenhouse case illustrated, but the Rittenhouse case did not illustrate that. Again, there is no evidence whatsoever that Kyle increased the volatility of the environment by bringing his weapon with him. This new law should apply only to public areas. And okay, so why is she mentioning the private property? Go up, watch. He used a rifle to protect used car lots. When he left private property, he killed 2 and injured a 3rd. So you see, he's mentioning the private property for a reason. Felony murder. Making the act a felony is justified. If a person brings a weapon into a curfew zone, he or she has committed 2 lesser crimes, violating curfew and carrying a weapon in public. Okay, so I guess 2 misdemeanors add to get you a felony? Is that how that works? Never heard of such a rule. Plus, a felony is appropriate for crimes that result in serious physical harm or the threat of serious physical harm. Bringing a gun to a riot qualifies as a serious threat to others, including to law enforcement officers. Classifying the proposed crime as a felony would have the benefit of giving prosecutors the ability to invoke the felony murder rule should a death occur. The felony murder rule applies to inherently dangerous crimes. However, bringing a rifle to a riot is not inherently dangerous. It can be, but if it's inherently dangerous, then why was Kyle the only one out of the hundreds of people who had guns that night in Kenosha to shoot somebody? A valid curfew can only be declared over an area so dangerous that a lockdown is necessary, and California has already decided that the possession of a gun in public can be dangerous, but not inherently dangerous. Therefore, any newly created felony involving curfews and guns would arguably be classified as inherently dangerous because the underlying acts are already classified as such. Yeah, no, I'm sorry, that logic doesn't hold. So, once a prosecutor is allowed to use the felony murder rule, intent and self-defense, I guess she meant to say self-defense, no longer apply. Let me read that again. Once a prosecutor is allowed to use the felony murder rule, intent and self-defense no longer apply.
Loco! Huh?
Because a defendant created the inherently dangerous situation. They are liable for the resulting death regardless of whether they intended to kill the person. The situation is the same in a bank robbery. Oh, we're going to compare what Kyle Rittenhouse did to a bank robber now. Robbing a bank is inherently dangerous, so anyone who commits that crime is liable for a death that results during the commission of the crime, even if the robber never intended to kill that person. So, if you have a concealed carry permit and you're walking down the street in the area of a riot, you can't claim self-defense even if somebody tries to attack you, which means that you can't go into that area protected. You have to be unprotected if you're going to be in public during a riot. That allows essentially free reign by rioters to tear the living hell out of anything they want. California should change its laws to prevent gunfights in the streets and make it a felony to carry a weapon in public in an area that is under curfew due to civil unrest. This will result in safer streets for the public. Oh boy, we've heard that one before, haven't we? You know, that's right, because California is so safe. It has so many gun laws. It's so safe. I mean, good grief. And law enforcement, and give prosecutors the tools to apply the felony murder rule to any resulting deaths. I told you before, and I've said it many times, I am not for the felony murder rule. I think it's abusive. To me, you should never be convicted of murder unless you intended to kill somebody, or your actions were so outrageous that you should have known someone was going to die from them. And this idea somehow that, well, to make the public safe, we should eliminate any chance for the public to defend themselves during a riot and allow the police to take care of it, makes no sense to me at all. And in fact, we know it doesn't make any sense. What happened in Kenosha? Did the police protect the public? In fact, I would argue that the reason why violence was abated on the night that Kyle was there was because Kyle and his compadres were out in force, and they prevented a lot of arson and a lot of assaults because they were armed. She wants to remove that. She wants the public to be unprotected and allow the rioters free rein. You see somebody being assaulted in the streets during a riot. You're in your own home and you see an assault. What are you going to do about it? Well, you can go out there and try to help that person, but obviously you're going to take a weapon with you. It's a riot. You want some self-protection. According to her, you have to go unprotected, and furthermore, everybody's going to know it. And if you go out there with a gun to protect that person, to stop it, and you get attacked and you use that gun to defend yourself, that's felony murder in her book. The same thing goes with arson. How are you going to put out a fire if you have to venture out into the streets unprotected? And again, you take a fire extinguisher with you and you try to put out the fire, somebody attacks you, let's say with an ice pick, and you shoot them, you're going to go to jail for murder. So that's what this is all about. The freedom to attack a community from within and kowtow the public to stay inside their homes, afraid to venture out to try to stop it. That's what she's aiming at.
With this bandana, I welcome you to the game.
Like my video and subscribe to my channel.